We've been pretty silent for the last 10 plus years regarding this very now public case of our house being taken for foreclosure for a tax that we felt was undue and unjust.
That's how Isabella County treated the Pung family, whose case was before the United States Supreme Court in February. The county foreclosed on the Pung family home for a tax debt of only $2,000. The kicker? Both the state's tax tribunal and its Court of Appeals ruled that the Pungs didn't even owe the tax in the first place. The response from the local tax assessor? I don't care. The county took title to the Pung's home and auctioned it off for a fraction of its full value. The home itself was worth about $200,000. That's 100 times the amount of the tax debt. But the county hawked the property at a fire sale auction for just $76,000, deducted the $2,000 debt, and returned the excess $74,000 to the Pungs. And what happened to the rest of the $118,000 of the Pungs' home equity? Vanished when it was auctioned off at a distressed price, all over a mere $2,000 tax debt. At oral argument, several justices expressed disbelief about the fairness of taking an entire home over such a trivial debt. But this is not the first time Michigan counties have taken the whole farm over small potatoes. In Wayne County, Michigan, Erica Perez lost her property after she accidentally underpaid her 2014 property taxes by a whopping $144. When she tried to pay the property taxes in 2018, she was told that she no longer owned the home. The county then sold the property for $110,000 and kept every penny. In neighboring Oakland County, the government took Uri Rafaeli's property after he accidentally underpaid his taxes by $8.41. That wouldn't even cover a burrito bowl at Chipotle. When the case reached the Michigan Supreme Court in 2019, Justice Richard Bernstein could hardly believe his ears.
You have a situation where people owed $8 and they lost their house. How is that equitable?
Our attorney, Christina Martin, put it bluntly in her closing argument.
In common parlance, people would call that stealing.
Mr. Rafaeli's case was a landmark win in Michigan. The state Supreme Court ruled, as a matter of state law, that the government confiscation of surplus equity after a tax sale violates the takings clause of the Michigan Constitution. Like its federal counterpart, that provision guarantees that the government cannot take property without paying just compensation. It would take nearly 4 more years before federal law would catch up. In the 2023 Tyler decision, the U.S. Supreme Court ruled that, as in Michigan, so it is everywhere. The government can't take more than it is owed. Just compensation is widely understood to mean the fair market value of the property at the time it was taken. But in Tyler, the court did not address how just compensation should be calculated. Some courts have measured the value of the property by whatever the government manages to get from selling it, even if the sale price is far below the property's actual value. And that's the issue at the heart of the Pung case. When taxes go unpaid, the government has the right to collect, and it has several tools available to do so. But there is simply no reason why property owners should lose their equity over a small mistake. As Justice Roberts wrote in the Tyler decision, taxpayers must render unto Caesar that which is Caesar's, but no more. The Constitution is ill-served by any rule that lets the government off the hook for failing to pay just compensation. This home equity theft issue creates a perverse incentive for tax collectors to maximize their bounty at the expense of homeowners. That's as true for Michigan as it is anywhere in the United States of America.